Hello, my name is Robert Larson. I'm the owner of the Larson Law Office, and I'm an attorney who focuses primarily on family law and estate planning. And today I wanted to talk about long distance or out of state parenting plans. And essentially, when we're talking about a long distance parenting plan, what we're referring to is where the two parents don't live close enough together that they could exchange the children on a regular basis. So, for example, you couldn't do a 50-50 schedule or even a schedule that's similar to that, or frequent weekends and things like that, because the parents live too far apart. And that could be out of state, so sometimes it's referred to as an out of state parenting plan, but sometimes it's within the state, but you're just living far enough apart that it's pretty much the same difference. You're too far apart to do frequent exchanges. So yeah, sometimes it's referred to as long distance, sometimes it's referred to as out of state. But either way, what it's referring to is the fact that one parent will be what's called the primary residential parent, and that's the parent who has the children the majority of the time. That's the parent who has the children when they're going to school and most of the year. The other parent would be the non-primary or non-residential parent, and basically that's the parent who doesn't have the children when they're in school, and so their time is usually going to be somewhat limited to school breaks and things of that nature. So a lot of times I see people doing these long distance parenting plans and they make a few mistakes. And so I just wanted to go over those. And so if you're ever negotiating a long distance parenting plan, these are some things that you really should consider. One is specific details on the responsibility for travel. That is not only the travel expense, but also the means of travel. And sometimes it can be fairly simple. Like, for example, you could just say, when father's getting the children, he's responsible for transportation. And however he does it is fine, whether he's driving or whether he's getting plane tickets for the children or whatever it is. And then you could say the same thing for the mother. When the mother gets the children, she's responsible for making those travel arrangements. But you also need to include information on how much notice you need to give on when those things are going to happen. But then also, your schedules need to have specific details about when parenting time starts during school breaks. So you could put down specific dates if that works for you, but sometimes it doesn't, because a lot of times it's more like a week after the summer break starts, or the first Saturday after summer break starts, or for spring break or fall break. You want to be very clear on when those breaks end and when they begin. And if you don't, if you just say father gets spring break, mother gets fall break, it could leave room for arguments and complications if you don't have those details in your parenting plan. So you want to make sure that your parenting plan has details about exactly when and how those school breaks are going to be divided, and how they and who's going to have the responsibility for making those transportation arrangements. Another thing is, there should be, this is something I see overlooked a lot, there should be something in there that says if the non-residential parent chooses to travel to where the children live, he or she would have the right to see the children. So it needs to be something where they have the right, not just something where they can ask to see the children or beg the other parent to see the children if they come to visit them. It should be something where they can say, hey, I'm going to come and see the children on such and such date, and it's going to happen. So for example, let's say you have a father who's in California and the mother's in Arizona, and the children are living with the mother in Arizona primarily. In that situation, the father could say, hey, I'm going to come out on a certain weekend and I'm going to spend time with the children, and you need to have that, or you should have something like that in your parenting plan. And there's a few things to keep in mind when you do that. Like I said, first of all, it should be a right. It shouldn't be something that the father has to ask for or beg the mother for. But it's perfectly reasonable for there to be some restrictions as well. So for example, it's perfectly reasonable for the mother to want to be notified in advance so that she can know what's happening and not make other plans instead. So typically you want to have some kind of order that says that the father needs to give a certain amount of notice before doing something like that. So it could be, typically I see about 1 to 2 weeks. Sometimes people want as much as 30 days advance notice. That's a little bit much, I think. But it should be more than just a day or two. And so typically you should have something that says the father needs to give a week or two of notice so that there's no complications from the mother already having plans in place. Also, if you're going to do something like that, then the father needs to agree that it's not going to interrupt the children's schedule. So there should be something in your parenting plan that says that the father can do that, but it's not going to interrupt the children's responsibilities and their schedule. So in other words, they're going to go to school, they're going to go to extracurricular activities and things like that. And whether that's the father taking them while he has them, or whether he's returning them to the mother so that they can get to school or activities, either way, they just need to have something that says that the children will continue to follow their schedules, regardless of whether the father comes to see them or not. There should also be a reasonable time limit as well. It shouldn't just be that the father's just going to come and have the children for the next couple of weeks. It usually would be limited to something like a weekend or at least a few days or something like that. So with certain restrictions, it's perfectly reasonable and appropriate to have something in your parenting plan that says that the non-residential parent has the option to see the children whenever he or she decides to travel to where the children live. So a third one is phone and video contact. And sometimes people don't think that's necessary because they're able to talk to the children on a regular basis. There's not really interruptions or anything like that. And I've seen sometimes where people say, well, I don't need that in my court orders. We get along. I talk to the children when I want. But at the same time, it's important to have it in there that says that you have the right to it. Because what happens if the parents have an argument and then one parent says, well, I'm not going to answer the phone anymore. You're not going to get to talk to the children. And believe me, that does happen. And then people get frustrated and then they go to court and it causes problems. So even if things are going well and you don't anticipate having a problem like that in the future, you should always have something that says you have the right to speak with the children by phone or video on a regular basis. And sometimes people put in a specific schedule. Sometimes it's left a little bit more open. And just because you have a specific schedule doesn't mean that you can't have more. So if you are getting along, you can just go off of whatever the two parents are doing, and there doesn't have to be restrictions to those specific times. But you want to have something in place in case the relationship kind of falls apart, and that way you have something that is considered a right and it's enforceable. And it works both ways too, because even for the primary residential parent, there are going to be times when the children are with the other parent, and usually that parent would want to be able to talk to the children too. So it's mutually beneficial and definitely a good idea to have something that says you have a right to regular phone and video contact. Fourth, and this is a big one, I see a lot of times, this is probably the most overlooked. I see this all the time. Going back to the situation that I mentioned where, let's say you have a father in California and the children are living with the mother in Arizona. What happens if the father moves back to Arizona? Well, right now, let's say you get some court orders in place and you get a parenting plan, and then 3 months later, the father decides he doesn't like being away from the children that much, and so he moves back to Arizona. Well, if you have an out-of-state parenting plan that says he gets the children during summer, during spring break, fall break, some of winter break, etc., then he's still limited to that even though he's living in Arizona again. So really what you need to say is what's going to happen if the two parents live close to each other again. And you could say, for example, you could say if both parents are living within the Phoenix metro area or within 25 miles of each other or 10 miles, whatever you want to say, you could put something in there that says that things are going to change if you live in the same location again. And you would want to specify what those changes would be so that you don't have to go back to court. In that scenario that I just mentioned, where the father moves back to Arizona after a few months, he would have to wait until the court order is a year old before he could go back to modify it. So he would definitely have the right to modify it because that's a very large change of circumstances from moving from California to Arizona. But court rules basically say you can't modify your court orders until they've been in place for at least a year, except for an emergency or things like that. So in a situation like that, you would hope the two parents would work with each other and be reasonable. But technically, the father could be limited to the time that he had based on living in California, even though he's moved back to Arizona. So I always like to have something in place that says what's going to happen if you move back to living within a close range of each other. And if not something specific, you could at least say something like moving back would be cause for filing for modification even though it hasn't been a year, for example. You could choose something to say something like that, but it's better to, I think, to have something specific that says we're going to go to a 50-50 schedule or every other weekend schedule or whatever it is. You want to have that in place already so that when you move, you have court orders that are enforceable and you don't have to wait several months just to go back to court. So anyway, those are a few thoughts on out-of-state or long-distance parenting plans. They can be really complicated. Those are the cases that are sometimes the hardest to settle because it's very hard to compromise there. Typically, one person is going to be the winner and the other person is going to be the loser if they're both trying to be the primary residential parent. And so we see these cases a lot, and those are some things to consider. And if you don't reach a settlement, you should at least ask the judge to put those things in place. So whenever you're going to trial on these types of cases, you want to say, look, I want to be the primary residential parent, but whether I am or whether I'm not, the non-primary residential parent needs to have these things in place so that if it doesn't go your way, then you would at least have the judge issue these orders as well. So anyway, hopefully you found this helpful, and if so, please subscribe so you can get more videos like this in the future. And if you have any questions, please let me know.